All right, let's dive right into this LSCPA brain hack session. We are going to completely master the absolute foundations of Philippine donors tax today. Look, if you're a BS accountancy student dreaming of locking down those four letters, CPA, at the end of your name, this explainer is literally built specifically for how your Gen Z brain processes and, more importantly, retains complex tax laws. Here's a massive reality check for you. You probably have what, 2, maybe 3 years until you actually sit down for the board exam. Rote memorization is just not going to survive a 3-year gap. Cramming might save you on a Friday quiz, but it completely falls apart for the boards. So we are rewiring how you study. We're going to train your brain to analyze, structure, and truly understand the mechanics of the law, instead of just staring at words on a textbook page. To pull this off, we're using a very specific framework today. We are intentionally stripping away all the visual clutter using clean, minimal slides. Why? Because it drastically reduces your cognitive load. We're going to heavily rely on active recall and concept contrasting. Believe me, this is exactly how you lock data deep into your long-term memory. Let's get into it.
Section 1. The DNA of the tax.
Okay, to remember the rules, you first got to understand why this tax even exists in the first place. Think of this as the actual DNA of the donor's tax. First up, it's a direct tax, meaning the financial burden falls entirely on the donor. You can't just pass the bill to the donee. Next, it's a national tax collected by the BIR. It's also an ad valorem tax because the amount depends entirely on the fair market value of the gift. But here is the absolute most important part. It is a privilege or transactional tax. The government isn't taxing the property itself. They are taxing your legal privilege to transfer that property for free. And thanks to the Train Law of 2018, this tax is strictly proportional. It's just a flat 6% applied to total net gifts that exceed 250,000 pesos in a given calendar year. And the best part? This rate applies no matter what. Whether the donee is your sibling or a total stranger, it's 6%. Those old, super complex tiered rates are totally gone. Now, to really anchor these concepts in your brain, we have to contrast them. In taxation, timing is literally everything. Inter vivos means among the living. Both the donor and donee are breathing when the transfer happens. Boom, that triggers donor's tax. But if the donation only takes effect upon the donor's death, that's mortis causa. It falls under succession laws and triggers estate tax instead. Always ask yourself, when does the transfer actually take effect? Moving on to Section 2, Anatomy of a Gift. So let's break down exactly what makes a donation legally binding. Because honestly, the BIR cannot tax a donation if a legally valid donation doesn't even exist. A gift isn't just handing your friend a laptop. It legally requires 4 specific things. First, the donor must have the mental and legal capacity to give. Second, you need animus donandi, which is just a fancy way of saying the pure intent to give out of generosity. Third, you need actual or constructive delivery of the object. And finally, you can't force a gift on someone. The donee absolutely must accept it for the contract to be valid. Need to lock all 7 elements into your brain for the boards? Just use this memory hack. ADED COCO. That stands for animus donandi, delivery, acceptance, donor's capacity, consent, object, and consideration. And just a quick note, the consideration here is simply the pure generosity of the donor. All right, Section 3, the timeline trap. Let's see how those elements build into the single most common trap examiners set for you, the timeline of the donation. When is a donation actually completed? This is exactly where examiners love to test your analytical skills, not just your memory. This is where students lose major points. They completely confuse the moment a contract is agreed upon under civil law with the exact moment it's finalized for tax purposes. You've got to separate these two in your head. Perfection relies on the cognition theory. That's the exact second the donor learns that the donee accepted the gift. It's the meeting of the minds. But completion, that happens upon delivery. And listen to me on this one. For tax purposes, the BIR only cares about completion. Why? Because it is that exact moment of completion, the delivery of the property, that triggers your strict 30-day countdown to file the donor's tax return. It is not perfection. If you base your 30 days on perfection, you're going to compute the penalties and surcharges totally wrong on your exam. Always anchor the 30 days to delivery.
Section 4, the rules of engagement.
Okay, we need to map out the strict, mandatory formalities under the Philippine Civil Code, because without these, your donation is legally dead. Lock these thresholds into your memory right now. For movable or personal property valued under 5,000 pesos, an oral donation is totally valid, but only if there's simultaneous delivery. Otherwise, put it in writing. If that movable property is 5,000 pesos or more, both the donation and the acceptance absolutely must be in writing. And for immovable or real property, like land, regardless of the value, it has to be executed in a public, notarized instrument. If you fail to follow those specific rules we just went through, the donation is void. That means the BIR will treat the whole thing as if the transfer never even happened. You can't just fix a void donation later. It is legally null from the very start. Beyond those formalities, the law also strictly prohibits certain transfers just out of public policy. Donations between spouses during the marriage? Void. Except for moderate gifts during family rejoicing, of course. Donations to public officials because of their office? Void. To prevent corruption. And honestly, donations between people guilty of adultery, concubinage, or the same criminal offense are also totally void. Civil law does not mess around.
Section 5, LECPA Bullet Review.
Okay, let's dive into a rapid-fire bullet review to force your brain into active recall mode. Don't just wait for me to give you the answer. Try to solve this in your head right now. What specifically triggers the 30-day filing period for donor's tax? Think back to our timeline trap. Is it when the donor makes the offer? When they find out the donee said yes? No. It is completion via delivery. Actual or constructive delivery is what starts that 30-day clock. Remember, tax liability accrues upon the actual transfer of the property. Next question. Let's say there's an oral donation of a 6,000 peso cell phone and it's handed over simultaneously. Is it valid? Apply our civil code rules to this exact scenario. It's movable property, it's 6,000 pesos, it's oral but there is simultaneous delivery. Valid? Absolutely not. It is completely void. Because the value hit that 5,000 peso threshold, the simultaneous delivery doesn't save it. It strictly requires a written document for both the donation and the acceptance to be legally binding. See how that works? The brain stores information better when it can compare it to something else. By constantly contrasting these rules, perfection versus completion, inter vivos versus mortis causa, oral versus written, you are building the neurological anchors you need to completely dominate the LACPA taxation exam. You aren't just reading anymore, you are analyzing like a future CPA. So you know the civil law requisites now, but how exactly do we compute the actual tax due under the train law if, say, the donor is a non-resident alien? We've mastered the foundation, but this leaves us with a massive question for our next explainer. How do international borders, reciprocity rules, and gross gift exclusions change the math? We're going to tackle the actual computations next time. Keep your notes clean, keep testing your recall, and I'll catch you in the next explainer.